Good morning to dear CPC students. I have come across a problem, maybe 2011 only, old notes, and it will be important for you. So therefore, I want to explain that problem. Question number 16, it was written like this, I don't know whether it is correct or not. A filed a suit against B, C and D for recovery of possession of his land. So according to section 26 of the CPC and order 4, this A instituted a civil suit against three persons, that is B, C and D. Okay. And B did not file the written statement. That means he received the summons under order 5. So he did not file the written statement opposing A's contentions. Secondly, C and D, what about them? They went abroad. So they are also not available. I think they also did not file the written statement. So under these circumstances, can A get the ex parte decree? Yes, 100%. Right? Now, you can say that, of course, this is my assumption. If the facts of the case are different, we can't help. But anyway, as far as this subject is concerned, so B did not file a written statement. Let us assume that he did not file a written statement. I am saying that C and D also, they might not have filed, or after filing they would have gone abroad. Right. So let us assume that all of them did not file the written statement. So definitely ex parte orders can be given. So what is ex parte? I have given a detailed notes on this topic. Ex parte means in absentia, in the absence of the party. If a decree is given, so it is called ex parte decree. When it will happen? So basically, as regards the written statement, you have to know, after you are served with the summons and along with the plain copy, then you have to file your written statement within 30 days. Of course, it can be extended up to 90 days. Order 8 Rule 1 says the defendant has to submit the written statement within, of course, I say 90 days from the service of the summons. Then, if he fails to submit his written statement within such period, then what is the course left to the court? The court can adjudicate the matter basing on the plaint, basing on the endorsed in the plaint. Right. So please remember, Rule 10 is an ex parte decree. Alright, Rule 10. A decree passed under Order 8 Rule 10 is called ex parte decree. And actually there is a cure for it also. This you have to know. What is the cure? The cure is mentioned in Order 9 Rule 13. Order 9 Rule 13. So you can file an application or you can file a petition for setting aside the ex parte decree. When? This is important. If you are able to convince the court with sufficient reason that as a defendant you wanted to appear but you could not. Your advocate wanted to appear but he could not. I will simply tell you one example. The case is posted finally for the written statement by the defendant on a particular day. Right? So the defendant statement was ready, but before the advocate wanted to file on a particular day, but the advocate received information that some of his relatives died. Then he informed the defendant, stating that, Baba, I am going to Repalli because some of my relatives died. You go to the court and apprise the court that this is the situation, my advocate will file it tomorrow. Right? This man belongs to Kondapi. So this man started from Kondapi to inform the court. But en route to his bad luck in Tangutur, the bet in between Tangutur, Jayavaram and Tangutur, I think, the bus met with an accident, that is, tire was deflated and they have to wait for the next bus, maybe around 1 or 2 hours time has gone. By the time he came to the court, the matter was adjudged because of the absence of the defendant. What to do? Of course, we all know rejection of a plaint according to Order 7 Rule 11. Order 9 Rule 11, I think. Okay, let us, I think it is Order 9 Rule 11. Appearance of the parties, yeah. So it's ex parte decree. Rejection of the plaint, sorry. Plaint means Order 7. Order 7 Rule 11 says rejection of a plaint. Here, the court, what he has done, adjudge the matter. That means they have decided the issue in favor of the plaintiff, since the defendant did not file any written statement. Now what to do? So Order 9 Rule 13, once again. So how to set aside an ex parte decree? You have to file a petition before the same court explaining the reasons. Of course, you have to enclose the affidavit also. In this case, that possibility is borrower and something I have told you, that case law, where it was held that the advocate should not file the affidavit, only the party should file the affidavit. Right? So here, since he did not submit the written statement, the case can be adjudged ex parte. It is called ex parte decree. Right? So please remember, in this connection, the court has, please remember, non-appearance does not necessarily entail an ex parte decree. That means an adjournment may be given. Please remember, the court has to weigh the merits of the case, and if the evidence does not support, then no ex parte decree. Support the claim of the plaintiff. But anyway, here the ex parte decree is given. Now the alternate is to file a petition for setting aside the ex parte decree. Now we have to write a couple of case laws also. So please note down the case laws. Maya Devi versus Lalitha Prasad. Maya Devi versus Lalitha Prasad, 2014. So Supreme Court held that even though there is no written statement, or when the defendant became ex parte, the court is duty bound. Here an important word. The court is duty bound to diligently ensure that the plaintiff stands proved. There should be material in the plaintiff's case, otherwise ex parte decree cannot be given. Another case, Balraj Taneja versus Sunil Madan, 1999. Here it is a cautionary decision by the Honorable Apex Court. Supreme Court of India held that merely on the ground of failure to file the written statement, the suit cannot be decreed. Ex parte decree normally should not be given. Right? So because, of course, the case is different. In this case, actually, he wanted to file the written statement basing on the income tax returns, income tax certificate. But those people, they did not give the certificate in time. That's why there is delay. So in such times, you can accept. The classic case is OS number 26/17, if I am correct, on the file of Markapur. So the defendant could not file a written statement within 90 days. There are 8 defendants. So most of them, they did not file. On the 90th day, only one of the defendants filed. Then for the written statement of others, till now, I am sure, till now, from 2017 to 23, it is being posted for a written statement. That is the situation. In the meantime, one of the defendants died. Third case, Bhogi Dola Tea and Trading Co. Limited versus Hiralal Sonam, 2008. Please remember, here it is a positive case for ex parte decree. In the absence of the written statement, when the defendant did not file the written statement, please remember, the court is obliged to consider the plaint and decide whether ex parte decree can be given or not, and based on that, ex parte decree can be given. Right? Friends, I have given 3 case laws on this side and that side. Please read them. So look to the video once or twice, because you are shortly to write the final exams for the semester exams. So with this, I am concluding. Thank you very much.